The time is just gone 8:22 a.m. We continue with the show this morning, and we're joined now by labor lawyer and mediator Patrick Deale. And this comes against the background of the CCMA ruling about a company's decision to sack an unvaccinated worker, saying that this was substantially fair. Patrick, good morning to you, and welcome to the show.
Morning, Aniet, and good morning to your viewers.
Well, Patrick, we knew that, this was going to happen at some point in time with the CCMA being faced with cases on issues surrounding unvaccinated people, where companies have been enforcing the vaccination rule. And this case is quite an interesting case because we found out about this woman who has refused to be vaccinated, and the CCMA ruling in favor of the company, saying that her refusal to be vaccinated and the company had acted fairly, and her sacking was upheld.
Yeah, no, that's correct, Aniet. We were kind of expecting this to happen, but now that it's happened, it crystallizes and obviously, in a way, clarifies how these cases are going to be treated in the future. And the road towards this point has been unraveling for the last 6 months or so, from way back in around about July and August last year. So we have a pointer now about the direction from this case, but remembering that the CCMA rulings or arbitrations are not necessarily binding on other CCMA commissions, and nor are they binding on the Labour Court or other courts for that matter, because the CCMA arbitrations are really tribunal rulings as opposed to judicial judgments. But nonetheless, it does indicate the view about where this is going to be going, and I think we can expect more of these things coming through into the future.
Yes. Now, obviously, in terms of this ruling, and the whole argument is about operating in a safe working environment. And that seems to be the key issue, the underlying issue. And looking at companies and their policies with regards to mandatory vaccinations. Now, how does this actually tie in from a labor law perspective, Patrick?
Well, you're quite correct. It is a health-orientated issue. And there are two sets of laws that are at play here that are interlinked. The one is the Labour Relations Act that's got to do with fair play between employer and employee, and the manner in which they treat each other. They must have their own set of rules about how they're going to manage the employment relationship within the workplace, on the one hand. On the other hand, you have a different set of rules which apply universally to all employers, and those are related to health and safety issues. And so you have the Occupational Health and Safety Act, which provides very strict regulations and guidelines on what employers must do to create a safe and healthy environment. And one of the things that it does, a central thing that it does, in fact, it requires employers to do health and risk assessments, safety assessments in their organizations, and to come up with a health and safety plan that must be implemented. And if there are going to be deviations from it, then consequences could follow. And the manner in which you implement those plans links into labor law. In labor law, rules are set, and those rules could include health and safety rules like the health and safety plan. And in labor law, where they actually are implemented in practice, those rules must be reasonable, they must be legitimate, they must be fairly applied and consistently applied. And all employers must know about them, and the rules obviously must be only applied where there are breaches of the rules. So that's the set of rule that tests whether the health and safety plans and rules are carried out and implemented properly within the context of labor law in the workplace.
Yes, Patrick, and I think the test is important, and the test here is fairness, and has fairness been applied both on the part of the employer and employee?
That's exactly it, Aniet. And in the context of this particular rule about vaccinations a mandatory vaccination policy, the rule must pass the test of being legitimate and reasonable. And insofar as that is concerned, in this particular case, which will set some sort of precedent of some description or guidelines at the very least for others who follow, that in this case, in the company Gold Rush, it concerns this company called Gold Rush, that they consulted with employees for over 3 months, and they agreed a set of rules that would apply. They published them, and they then went ahead to implement them. So there was proper consultation. There was a buy-in from majority of the employees at the company. And so one can conclude that the rule was legitimate and reasonable. And therefore, the company at that point was able to implement it in its workplace without fear of it being attacked as being illegitimate or unreasonable. Because if that happened, it would stumble on the first point of implementation. But in this way, because they had a prior consultation and a buy-in, it was fair and reasonable to proceed to implement a mandatory vaccination policy.
And just finally, Patrick, in the event of, this consultations, as you mentioned, had taken place, it took place over a period of 3 months, and an employee who is not happy with this policy, with this mandatory vaccination policy, what option would they have if they possible, besides, leaving the employer, resigning from the company and leaving, if they don't want to conform?
Well, if they don't want to conform, that would be the consequence. They would either have to resign, or the employer ultimately would have a right to dismiss the employee on the grounds of incapacity. Because what happens in a situation like that, if the due process has been followed for this particular employee, in this case, as it has been found to have been followed properly, then there's no way out. Simply because the rule being reasonable, it takes care of the duty of care that an employer has for all of the other employees from the majority. And one employee who can't be accommodated because of whatever reason she had for not taking the vaccination can't put the rest of the employees at risk. And therefore, she's incapable of doing her job. And therefore, on that basis, there's no commercial rationale in the employment relationship, and the employer would be entitled to terminate. And that's why this case was found to be substantively fair. And I believe it's the correct decision.
Well, Patrick, thank you very much for that, for your time, for unpacking this with us this morning. And we do appreciate you taking time out. All the best to you.
My pleasure. Take care. Thank you.
Patrick Deale, a labor lawyer and mediator, with us this morning against the background of a CCMA ruling in favor of the company, their decision to sack an unvaccinated worker, saying that this was substantially fair. This is obviously quite an interesting and obviously creating precedent for what is to come. And I'm sure many companies have come up with these policies. The time is just gone 8:31. We come back, we'll be joined by CEO Penny Appeal South Africa. We'll be talking with Shanaz Parak.